For the abstract, this paper consists of a discussion to identify the English law application and its development in Malaysia's domestic law. And it is to aim for further knowledge about the English law in Malaysia and its development. Legal system can be defined as overall legal regime of a country, provides institutions, principles, rules, and methods for regulating the relationship between law and society. Malaysia's legal system is heavily influenced by English legal system, and Malaysian law is mostly based on English common law. According to Farid Sufyan Shoaib in his article, English common law can be defined as common legal system as practiced in England, in contrast to civil legal system as found in continental European countries such as France and Germany. Due to the colonization towards Malaya, British has brought the English legal tradition into the Malaysian legal system, and the application of the English law slowly revolved during British colonization. The first Charter of Justice in 1807 is the first intervention of English law in Malaya. The first Charter of Justice consists with the criminal and civil case, and Sir Ralph Rice, which is the English judge, has mentioned that the criminal law was only part of the law of England, which was forced in Penang. In civil matters, justice was to administer among the native population with respect to their laws and customs. From here, English law has developed by the establishment of a new Charter Justice until it had a significant effect on the modern Malaysia's law till now.
English law either can be known as common law is an unwritten law, which means that the law that are not enacted and not found in any constitution. So according to a book, An Introduction to the English Law of Contract for the Civil Lawyer, the common law is the decision of a particular group of court which existed in England from the early Middle Age until the late 19th century. So the king courts or also could be referred as common law courts. It has stated that in early days British Royal has used this kind of law making decision for the cases. So thus it become a general knowledge to community on what effect of the law on plaintiff nor defendant. In addition, Encyclopedia Britannica has stated that the common law of England was largely created in the period after the Norman conquest. The Anglo-Saxons, especially after the accession of Alfred the Great, had developed a body rules that resembling those being used by the Germanic people of Northern Europe. However, there also has the rules of equity in this common law. It can be defined as the law which can be found or traced back to the decision of a separate group of court which grew up initially under the control of the King Chancellor and developed from the late 14th or early 15th century. So after the King Court of Common Law were already established until the late 19th century, it can be concluded that the equity law were made from people from royal to prevent the harshness in common law. Common law has become part of the law of Malaysia due to colonies of British in old days ago. Furthermore, it well-known fact that English law were applicable in Commonwealth countries, which were British colonies. Based on the history, it was acceptable to apply English law in Tanah Melayu. As stated by Journal US-China Public Administration, the application of English law will also influenced by interpretation made by judges, either in translating certain places, construing stated, or elaborating on particular circumstances. However, the third edition of Business Law book also state that not all the England common law and rules of equity form part in Malaysian law. So this is because the common law position of Malaysia could well be superseded and changed by an Act of Parliament later on. So should our legislature decide to define and somebody in the statute the limits and extent of sovereign immunity in the country. There also have important factor to apply English law in Malaysia. It is applied only in the absence of local statute on the particular subject. And secondly, only that part of the English law that is suited to local circumstances will be applied provision to Section 3 Civil Law Act in 1956.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nurul Ashamti Jamaluddin, and the application of English law in Malaysia. The Civil Law Ordinance, Extension Order 1971, which entered into force on 1st April 1972, expanded the Malayan Civil Law Ordinance 1956 to Sabah and Sarawak. Nonetheless, the legislation of Sabah and Sarawak that permitted for the application of English law in those states are still in practice. The court shall use the common law in England and the rules of equity as applied in England on the date of the ordinance's entry into action, which is 7 April 1956, just like is stated in Section 3 Clause 1 of the Civil Law Ordinance 1956. This has been taken to suggest that English legislation are not applicable in the Federated States of Malaya, while Sarawak's application of Laws Ordinance 1949 and Sabah's application of Laws Ordinance 1951 provide broader provisions for the application of English law. Section 2 of both statutes states that the common law of England, equities doctrines, and the statutes of general application as administered in England at the time the statutes are enacted shall be enforced in Sabah and Sarawak respectively. It must be relevant to such qualifications as local circumstances and native customs require. Thus, English legislation of general application implemented to East Malaysia than in West Malaysia. The application of laws ordinances in Sabah and Sarawak were replaced insofar as they pertain to any item on the federal list of topics with the extension of the Malayan Civil Law Ordinance 1956 to East Malaysia. The majority of the provisions of the Sabah and Sarawak application of laws ordinances were already included into the Civil Law Act 1956 as updated in 1972. This entails that, subject to local circumstances, the application of common law, equity and legislation of general application as applied or in power in England on 1st December 1951 in Sabah or on 12 December 1949 in Sarawak. Next is the general application of English law. Section 3 Clause 1 applies common law and equity rules as well as English statutes of general application in Sabah and Sarawak accordance with the following qualifications: absence of local legislation, cut of dates, and local circumstances. Firstly, it is included in the opening proviso in the absence of local laws. Section 3 Clause 1 CLO 1956 and Section 2 Civil Law Enactment 1937 are from the Section 3 Clause 1 CLA 1956, both of them contain the same qualification. The qualification is only used when there is no local status on the issue. The statutory acknowledgement of the judicial practice of relying on English law to improve gaps or lacuna in the local legal system. Secondly, cut of dates. Only common law and equities principles as well as English legislation of general application functioning in England on the dates mentioned are applicable in Sabah and Sarawak. It can be used to fill the gaps lacuna in the local legislation. According to what is stated by the Privy Council in Lee Ki Chong against 4 Nombor Ekor, their lordships are not required to review the developments in English law after 1956 because according to Section 3 Clause 1 CLO 1956, which is identical to Section 3 Clause 1 Clause A CLA 1956, any subsequent march in English authority is not embodied. Lastly, local circumstances, which means that English law is only applicable to the degree allowed by local circumstances and people, and up to qualifications imposed by those circumstances. English law may be better adapted in its own place, but it doesn't always translate well into the local setting, when the application is a completely foreign system on a culturally and socially different than English society. This last qualification, which is found in the final provision of Section 3 Clause 1, is usually referred to as the local circumstances.
Similarly, in the case of wills, as in the Code of Abdullah 1835, the court approved the deceased's request to transmit the entirety of his assets via wills, despite the fact that it violated Islamic belief. However, the judge viewed the deceased's intention as legitimate and in accordance with the legislation that was in effect in the locality. As a result, the will was determined to be legitimate and enforceable, notwithstanding the provision in Islamic law that only 1/3 of the estate may be given through the will method. The effect of English law is particularly visible in bigamy marriage, where Sir Benson Maxwell in his report to the British Secretary has highlighted the difficulties in implementing Islamic law within English law of inheritance. As stated, it will be impossible, for example, to pronounce the eldest son of a Mohammedan to be the heir because his father had 2 wives at the same time and he was the offspring of the second marriage. But regardless of the level of accommodation, the cornerstone of the legislation remains the English law of inheritance. It is apparent that the use of the English concept was so widespread inside the state settlement. It also demonstrated that the effect of English law occurred through many methods such as substantive rule, judicial precedent or interpretation made by judges, as well as in the law of process, and progressively eliminated the application of Islamic law. From another aspect, the continued impact of English law is the result of a residual of historical provisions in present law. As we all know, the execution of law was based on written orders. The legislation cannot be enacted or implemented by the authority unless the clause is included. Meanwhile, the Sharia court's jurisdiction has remained unchanged in recent days. As a result, certain effort must be made in order to broaden the Sharia court authority as well as to raise the limit in offering interpretation in Islamic subject matter, even if it is not explicitly stated in legislation today. After 15 years of independence and several declared successes, Malaysia should feel strong enough to build its own legislation, exactly like Australia has been doing.
Assalamualaikum warahmatullahi wabarakatuh. I beg to Madam Amani. My name is Nur Izzati binti Saleh, and for the conclusion is Malaysian legal system bears significant trace of British influence. The existence of English law is critical in regulating the diverse religious belief in Malaysia's society. Malaysia's current process and law are critical because what has been proposed does not fully replace Malaysian legislation. To a significant extent, the courts, judges, and judicial process are still in place. What is edge is that the judges put in greater effort with assistance from the councils and academic to create the judges-made law in Malaysia mold. Malaysian legal system bears significant trace of British influence. The existence of English law is critical in regulating the diverse religious belief in Malaysia's country. There is no doubt that English law played a significant role in our legal system up until independence. As a developing sovereign nation, it was critical to uphold the rules of the land that we were accustomed to. As a result, Section 3 of the Civil Law Act 1956 and the application of Law Ordinance of Sabah and Sarawak played a significant role in ensuring the legal system certainty and stability. However, after more than 60 years of independence, it may be time to revisit Section 3 of the Civil Law Act 1956 in order to streamline the between West Malaysia, Sabah and Sarawak by officially repealing the application of Law Ordinance of Sabah and Sarawak, as well as to purge archaic, outdated and redundant provision in the Act. English law is applied in Malaysia through the common law. Article 160 of the Federal Constitution rules the common law to be applicable insofar as in operation of the Federation or any part thereof. Section 3 of the Civil Law Act 1956 stipulates that the common law of England and equity principle may be applied. It should be emphasized that the use of this only permit in situation with no specific Malaysian law applies. As a result, while Malaysian law can be applied in Malaysia, it is apparent that it does not displace Malaysian law, rather it is a supplement. That's all from me. Thank you.